Date and time set for a restitution hearing, sentencing and a restitution hearing.
That is correct.
This case opens in a deceptively quiet way, but don't let that fool you. What you're about to witness isn't just a dry financial hearing. It's a collision between trauma, credibility, and the cold precision of the law. On one side, you have a victim seeking restitution for therapy after a workplace assault. On the other, a defendant whose future hangs on how this court interprets what's real, what's provable, and what's legally connected to the crime. Judge Simpson, known for his meticulous approach and low tolerance for speculation, immediately frames this as more than a paperwork exercise. Restitution is not sympathy-based. It is evidence-based. Every dollar must be tied directly to the defendant's actions. And that's where this case becomes volatile, because trauma doesn't move in neat lines. Healing isn't linear, but the law demands precision. This hearing will dig into therapy methods, invoices, insurance, credentials, and timelines. It will question whether pain alone is enough or whether proof must follow strict legal form. You'll hear emotional testimony about panic attacks, sleepless nights, and shattered trust. You'll also see a judge dissect those claims with surgical calm.
Parties ready to proceed?
We are. I already know where you want to start.
Well, after the holiday, really didn't want to start at all, but I'm here. What are you suggesting?
Well, Judge, I think with this, I guess you let me pick, I'll go with the sentencing. I believe we previously indicated that we've reviewed the recommendation. There's no corrections that need to be made to the report. We just have it. Obviously, the restitution was one issue. That's why we have a hearing on it, and also the recommended 3 days of jail time for the bond violations. Right, and that's another point we wanted to address.
Okay, the bond violations, right? Well, why don't we start with the restitution hearing? Let's get that out of the way, and we can try to formulate something that encompasses a whole sentence. And counsel, there was one issue that came up and received and I think copies were sent to the parties because the court had reviewed it.
So I know, Ms. Morley, you submitted a request today for lost wages as well as reimbursement for therapy costs. So we've already had a conversation about just proceeding forward with the request for therapy costs and not lost wages. So we're going to just talk about therapy costs today. Correct. As far as that goes, it's my understanding that you've received 2 types of therapy. Is that correct? That's correct.
This is where the hearing narrows from abstract justice into concrete dollars and definitions. The court draws a hard boundary. Lost wages are off the table. Only therapy costs remain. That tells you something critical about how restitution works. It's not a blank check for suffering. It's compensation for specific measurable harm directly tied to the offense. Notice how Judge Simpson immediately begins categorizing 2 types of therapy. That's not curiosity. That's legal filtration. Each modality will be tested for legitimacy, necessity, and causal connection to the crime. Talk therapy is familiar territory for courts. It fits neatly into recognized medical frameworks. But the second form, craniosacral therapy, already introduces uncertainty. And in court, uncertainty is dangerous. This is the tension victims often face. Emotional reality versus legal structure. From a human perspective, if trauma drives you to seek help, that feels valid. From a legal perspective, the court must ask, is this a recognized treatment? Is it licensed? Is it medically necessary? Is it directly caused by this defendant's actions?
Can you tell me what those 2 types of therapy are?
The first type is more of a traditional type of therapy, I guess you would say. And the second type is somatic craniosacral therapy.
When you say traditional type of therapy, are you saying like psychotherapy?
Yes.
Okay. And can you tell me who you see for that?
I see Wendy Polinsky for that.
Okay. Do you know about how much you're requesting for psychotherapy specifically today?
I believe it was close to $3,000, maybe a little less.
For just psychotherapy?
Oh, I don't know, between the 2.
Okay, so if I told you 145904, does that sound right? Okay. Can you tell me, does insurance cover those appointments for you?
It does.
Has it always covered those appointments for you in total?
Not in total. I do pay some out of pocket.
Okay. So has your out-of-pocket cost for those changed over time? When immediately following this incident, can you tell me about how long it was before you had your first psychotherapy appointment?
After September 22nd, I had a therapy appointment. I think it was a couple of days after. It was over the weekend.
Okay, and was it on, have you had appointments ongoing since then, or did you stop?
Ongoing.
Okay. And do you know about how many appointments you've had?
I've gone at least once a week since September 22nd. But
If I said 22 appointments? Okay. So talking a little bit about psychotherapy, can you tell me just kind of what that modality is like as far as therapy?
yeah, I originally started going to that particular kind of therapy before this event even started because of the toxic workplace that I was working in that Jason had created.
This moment quietly shifts the entire gravity of the restitution request. The victim admits she was already in therapy before the incident. That doesn't invalidate her trauma, but legally, it complicates everything. Restitution isn't designed to fund general mental health care. It exists to compensate for harm caused by this specific crime. From a courtroom standpoint, this creates a timeline fracture. If therapy began before September 22nd, the court must now separate what treatment was already necessary from what became necessary because of the defendant. That's not emotional parsing, that's legal math. You can hear Judge Simpson's mind recalibrating in real time. He's no longer just asking what therapy costs. He's asking what changed, what is new, what is directly attributable. Because without that distinction, the defendant could be made financially responsible for issues that predated the offense. This is where many restitution cases falter. Life doesn't reset when a crime happens. People carry prior stress, anxiety, and trauma, but the court cannot retroactively assign responsibility for everything that follows unless it can be cleanly linked.
And after this event, I started going at least once a week, and that was really helped me kind of realize that this person that I had looked up to and thought was a mentor was actually very manipulative and abusive to me.
But so when I'm asking about modality, I mean, is it a movement therapy? Is it a talk therapy? Something, okay. Is it one-on-one?
Yes.
Is it in person?
Yes.
Okay. And so what makes these appointments after the incident with the defendant in September different from the appointments before, if anything?
Or I was just hoping that I could go to therapy for generalized anxiety around going to this workplace, hoping that therapy would help. After the event, it was more centered on coming to terms with the fact that this guy that I admired and looked up to was abusive and trying to work through how I got to that point and just trying to understand how I had worked for somebody like that for so long.
Hold on a moment. So you were seeing this same therapist prior to September 22nd?
That's correct.
For how long?
I would say a month before. Maybe 2 months. Or I can't remember. I think her letter specifies.
I don't.
I was just about to.
Okay, go ahead.
Has your therapist, Wendy Klinsky, written a letter explaining her treatment related to this incident for you? If you saw that today, would you recognize it? Can you tell me, is there a specific link between those post-September 22nd appointments and the defendant's actions on September 22nd?
Yeah, I would say. I mean, every single therapy appointment that I've been to since this happened has been about this incident.
In what way?
Trying to heal from the trauma of it and understand how I was in this position in the first place.
Okay, turning to the second kind of therapy you mentioned at the start, what is that?
That is craniosacral therapy, which I did online. Would you like me to describe it?
Please.
After the event happened, I would say around October time, I was experiencing some PTSD, And my friend who knows therapists suggested that I go see this craniosacral therapist for my PTSD because it was getting so bad where I couldn't even eat or sleep or accept like a hug from someone. Much like dissolve into panic attacks. And so I started seeing them to be able to touch the trauma of the event and relive the event without dissolving into panic attacks every day.
This is the emotional core of the hearing. The victim isn't speaking in abstract terms. She's describing survival, panic attacks, loss of appetite, fear of human contact. These are not exaggerations. They are textbook trauma responses, and in any human sense, they demand compassion. But a courtroom is not a therapist's office. It's an evidentiary arena. The judge isn't questioning whether she suffered. He's determining whether this particular form of treatment qualifies as something the law can reimburse. And that's a brutal disconnect. Craniosacral therapy sits in a gray zone. Some swear by it, others dismiss it as pseudoscience. Courts require more than belief. They require credentials, licensing, verifiable structure. The law doesn't operate on "it helped me." It operates on "it is recognized and medically legitimate." This is where victims often feel re-traumatized by the system. They open their pain to scrutiny, only to find that the legal framework is colder than expected. The judge isn't denying her suffering. He's questioning whether the state can compel the defendant to pay for a treatment whose legitimacy cannot be established.
Okay. So you have psychotherapy, which is talk therapy. What type of activities do you engage in this second type of therapy?
I would say the initial part of the session is talk therapy, and then we go into more of the craniosacral part of it, which is lying flat and kind of envisioning the trauma and going to the event without and being able to touch it, I guess, without dissolving into panic attacks.
And you said you did it online.
Yes.
How does that work?
The two therapists and I start off with conversation and just kind of talk about like where I'm at, how I'm feeling and everything like that. And then we go into, I like lay down in, my room or wherever I feel comfortable, and they kind of guide me through kind of like a meditation. And we slowly work through the trauma surrounding the event, the trauma that I have after the fact, daily trauma, kind of just talking about like how to kind of access that part of my brain and myself. So it kind of helps me alleviate the stress and trauma, both physically and mentally, in a way that the talk therapy wasn't addressing.
So I have that you started craniosacral sessions in February. Is that correct?
That's correct. Yeah.
Okay. And so you've only had 7 sessions. Is that correct?
Yeah, that's all.
The most recent being in June. And as far as those 7 sessions, did you have any insurance coverage for those sessions? Can you tell me how much your out-of-pocket expense was? Okay. If you saw an invoice for those sessions today, would you recognize it? Your Honor, the people move to admit People's Proposed Exhibit number 3.
Any objection of what here?
I didn't admit the previous ones, did I?
You did not.
Your Honor, the people move to admit People's Proposed Exhibits 1 and 2. Thank you.
Exhibits 1, 2, and 3 for the record are admitted.
Thank you. Clearly undercaffeinated.
Apparently.
Can you tell me a little bit about how have these craniosacral sessions helped at all with your PTSD?
Oh, absolutely. Yeah. And I will say that I thought it was all woo-woo, just BS kind of therapy. And that's why I waited so long to try it. But I think that this has been.
This line is honest, vulnerable, and unintentionally dangerous in a courtroom. Calling a therapy woo-woo may resonate with viewers, but it plants doubt in a legal setting where legitimacy is everything. Judges don't rule on personal belief. They rule on standards, credentials, and evidence. The moment a treatment is framed as unconventional, the burden shifts hard onto the person requesting reimbursement. From the court's perspective, this isn't about whether it helped her. It's about whether the system can verify that this is real therapy, administered by a licensed professional connected to the crime. Courts don't fund experiments. They fund recognized treatment. What's unfolding here is a classic clash between lived experience and institutional proof. She is saying, I was drowning and this pulled me back. The judge is thinking, who provided this? Under what authority? With what credentials? In everyday life, we choose what heals us. In court, healing becomes evidence, and anything that cannot be independently verified becomes fragile.
One of the most helpful modalities of therapy I've had in terms of trying to heal from this.
And so as far as the invoices go, I noticed that her address is in North Carolina. Do you happen to know, does she have a license or a certificate or?
Yeah, she was originally living in Ann Arbor, so she started out here and she is licensed to do this kind of thing.
And what kind of license do you need to do this kind of thing? Do you happen to know? Okay.
How do we know that she's licensed? And through whom?
Do you know through whom she's licensed?
I don't. I mean, I can find out, but I don't know.
Well, okay, go ahead.
So just to be clear, in total for the craniosacral sessions, because it's 7 appointments at $90 each, that's a request for $630 for those appointments. And then we previously said $1,459.04 for the psychotherapy appointments. Is that correct? So you're asking for a total of $2,089.04 today? Okay. Nothing further at this time, Your Honor.
Thank you. Mr. Allen, can you hand me those exhibits?
Ms. Marley, I just have a few questions for you, just to clarify a couple of things. It should not take very long. I kind of specifically wanted to ask you about the cardiosacral therapy. So this Michelle Tupko, the woman that wrote the letter, so it's somebody that your friend recommended, correct? Okay. And you didn't go to your insurance company to see if that's something that could be covered by insurance?
Yeah, she doesn't accept insurance.
She does not accept insurance. Okay, and did you look for her through your insurance? Like my insurance lets me go on the website and search for professionals to see. Okay, did you find her in the list? Okay. And so these are virtual sessions, correct? So you understand that Ms. Tupko lives in a different state, right?
Yes.
North Carolina, is that right? Okay. Do you know if she has an office?
She does.
Well, have you seen it? Have you been there?
I've not been there, but I've, during our virtual sessions, I see it.
Okay, and you said there was a partner also? Do you know if their business has a website?
They're actually making a website right now.
Okay, so no
Hey,
website.
what?
They're making a website as we speak.
Well, because when I was looking for the Way of Wild Remembrance healing therapies, I was not able to find anything online. So that's why I was curious so no website to your knowledge, correct?
At this point, the hearing stops feeling like a therapy discussion and starts feeling like an audit. No website, no listing, no verification. Everything about this provider exists only in conversation, and that's fatal in a courtroom. Courts live on records. They trust what can be independently confirmed. A provider with no online presence, no searchable credentials, and no licensing trail doesn't just raise eyebrows. It raises the possibility that the court is being asked to enforce something it cannot legally recognize. You can feel the room shift. The judge is no longer asking, "Did this help you?" He's asking, "Does this even exist in a form the law can acknowledge?" This is the hidden cruelty of legal process. Trauma is real. Healing is real. But the law cannot operate on invisibility. If something leaves no trace in public systems, courts cannot compel others to pay for it.
Okay, and you said it is your understanding that Ms. Tupko is licensed, right? But you were not able to find through your insurance, correct?
Correct.
Okay, did you verify her license in any way?
I am not in the modality to do that, so I don't verify licenses, so no, I didn't.
Okay, so you just assumed she was licensed?
I took her at her word that she's licensed.
Okay, but you've never seen any confirmation, never looked into it yourself,
I
correct?
look her up online and see if she's licensed.
Where would you look her up online?
Google her name, you can see that she's licensed.
Well, I did Google her name and I only found a LinkedIn profile. Are you familiar with it, LinkedIn? Okay, and I found, there's no picture of an individual, but the only person with that name, it says Ann Arbor, is a Thai massage therapist.
Well,
He's a what?
Thai massage.
Got it.
Oh, you looked her up on Google? Okay, but you said there's no website though, right?
Right, I'm making one right now. Yes.
How do you know they're making one right now?
Because we've discussed it. I'm a web designer.
On what?
We've discussed it. I'm a web designer.
Were you aware that this is something that I learned while I was preparing for this hearing, that there's the Biodynamic Cardiovascular Therapy Association of North America?
No, I was not aware of that.
Okay, well, and so there's a website that lets you look for practitioners who are licensed specifically to perform biodynamic cardiovascular therapy. And I was not able to find Ms. Tupko in Michigan or North Carolina or really anywhere through that website. That's surprising to you?
No, I'm just not right now.
Okay.
Well, we may have to get that person up here to testify because I don't.
This is the moment where the judge signals real doubt. Calling a provider to testify is not routine. It happens when the court cannot determine legitimacy through documents alone. In other words, the system doesn't trust what it's seeing. And notice what's happening psychologically. The victim came to court to be heard about harm. She now finds herself in a position where her healer may be placed on trial instead. The focus shifts away from what happened to her and toward whether her recovery path is even valid in the eyes of the state. This is how restitution hearings can become emotionally disorienting. You walk in seeking justice for pain. You walk out defending your choices. Judge Simpson isn't accusing her of lying. He's acknowledging that without credentials, the court cannot legally connect this therapy to the offense. The law is not equipped to navigate spiritual, alternative, or non-standard healing paths. It only knows what it can name.
Do you know why they're? Well, I'm sorry, Mr. Malinka, but I just got to get some things clarified here. Did you read this letter of May 3rd? Did you request this letter from them?
Yes, I did.
And because I'm looking at Exhibit 4, they don't have letterhead?
No, they don't. They're not very web-based people.
A letterhead doesn't take web. I mean, I just.
It takes design. That's not something that they're good at doing, and that's why.
Well, you know a lot about these people, but why don't you just answer my question?
Well,
My
that's
question.
the thing.
Mr. Malinka, go ahead, because apparently I'm not going to get an answer. Go ahead.
All right, and just to clarify, I believe you
You know what?
you testified that you started this cardiovascular therapy in February, correct?
Correct.
Okay, so you didn't increase your sessions with your psychotherapist, you just started doing a different type of therapy on your
I
own.
am in a paper available, which is once a month.
Okay, but you were not referred to them through your current therapist, correct?
This question may sound minor, but legally, it's massive. Referrals act as bridges of legitimacy. When a licensed provider directs a patient to another specialist, it creates a documented chain of medical necessity. Without that bridge, the court sees this therapy as a personal choice rather than a prescribed response to the crime. From the bench, Judge Simpson is mapping causation. Did this therapy arise because a professional deemed it necessary due to the assault? Or did the victim independently seek it based on personal belief and recommendation from a friend? That distinction determines whether the expense belongs to the legal aftermath of the offense or to personal health management. Courts are built on causation. But for the defendant's actions, would this cost exist? If the answer becomes uncertain, restitution weakens. This is where emotion and law collide head-on. To a person in crisis, any path toward relief feels necessary, but the court must ask whether the defendant legally caused this specific expense. And when therapy begins without professional referral, without documented necessity, and outside standard medical systems, the court's ability to impose payment collapses.
Okay, well, your psychotherapist letter indicated that you started therapy with them in June of 2020, correct? So you sought out that months prior to the events of September 22nd, correct? Thank you. I don't have any other questions for you.
How are these bills to the Way of Wild Remembrance paid?
Through your PayPal.
You have the PayPal receipts?
Not on me now, but I can get them.
You should be able to download them now and send them to the prosecutor. I want to see that these were paid. And I'm still curious. Let's back up. Great Lakes Psychology Group. You actually go in there?
Yes.
Okay. You were seeing them before the date of this incident, right? Before September 22nd. And who was this individual that referred you to Way Wild? Remember it?
One of my friends who had done some work.
Who was that?
Who was my friend?
That's my question.
Her name is Susan Ulrich.
Last name. Did she say how she knows the therapist?
She had some work done from them when they lived in Ann Arbor.
Somewhat.
Some work done from them when they lived in Ann Arbor.
Conversation you had about them being licensed. Did they say who they were licensed through?
They did, but I don't remember if that was the first talks that we had during our first conversation.
Somehow or another, I need to download payment records if they exist for that. Like I said, there shouldn't be a reason she can't get them right now. Counsel, I am a little bit worried about who these people in North Carolina are because I don't.
When a judge says he is worried, that's not casual language. That's judicial alarm. Courts rarely voice suspicion openly. Here, Judge Simpson is telling everyone in the room that the foundation of this restitution request may be unsound. He isn't questioning the victim's intent. He's questioning whether the court is being asked to funnel money to an entity that may not even be a legitimate business. No license trail, no professional registry, no verifiable credentials. And now, payment records that don't line up cleanly. This is the legal nightmare scenario. The court risks ordering restitution to a provider it cannot confirm exists within any regulatory framework. That would transform restitution from justice into endorsement. Judges carry institutional responsibility. Once they attach the court's authority to a payment, that order becomes part of the state's machinery, and the state cannot fund shadows. This is also where viewers should notice how fragile restitution really is. It's not about who deserves help. It's about what the court can safely enforce. And enforcement without verification is chaos.
I don't know whether it's a licensed therapy or anything along those lines. You said your insurance rejected paying for them?
Yes, that's correct.
What was the insurance basis for rejecting payment?
Out of network.
Pardon?
Out of network.
That was their sole reason? As part of my other concern, counsel, so that you can be aware, and I'm going to take a break because I'm going to try to do some digging on this a little bit because, anyway, and there may be a valid reason for it, but I don't have letterhead, which would seem unusual of drafting a letter. But also, I noticed that only one of the therapists signed this letter of May 3rd. And I'm worried about the credentials of this individual only because I typically, when we see these and there's therapy, not that there has to be, I usually have some letters after their name denoting some type of degree or something. And I have nothing on this letter at all. And I don't. Well, I have nothing on the letter and I am not finding them anywhere. I also can see the payment. It looks like payment records from Great Lakes, but I don't see payment. I'm going to need that if I were to even consider awarding it, the payment records to the other place. I want to clarify one thing. Ma'am, you testified here that they don't accept insurance. So if they don't accept insurance, why'd you submit it to your insurance?
Just to see if it would be covered. I did that with another doctor who's out of network.
Well, hold on a second. To see if they would cover what?
Anything out of network. Sometimes my insurance does.
But they had already told you they don't accept it?
Right, but I figured I would try just because it was so expensive.
Okay, so they told you they don't accept insurance. You're telling me you submitted it to your insurance after that?
Yes.
Okay, I'll ask, what would be the purpose of that?
Sometimes my insurance covers things that are out of network from out of network providers, even if it's a small amount. So I thought I would try to see if they would cover any of it.
We're gonna take a recess. I want to see the one thing I want to see is I want to see these receipts from PayPal. I need to see them. Court's going to stand in recess. And let me just say that the reason that so that the record is clear that the court called counsel and probation back is because I had received a communication from a Tanya Desfantes regarding the, I guess, credentials of Miss Tuco.
This is where the judge steps out of passive adjudication and into investigative posture. Courts rarely reopen proceedings unless something serious arises. That communication triggered internal review. Staff searched, databases were checked, registries were examined, and nothing surfaced. This transforms doubt into institutional conclusion. It's no longer just cross-examination. It's the court itself saying we cannot find this person anywhere. What follows is not skepticism. It is evidentiary failure. When a judge says we searched and found nothing, that means the system has exhausted its verification pathways. And in law, absence is decisive. The judge's language is careful, respectful, restrained. But the implication is devastating. If a provider cannot be found in any licensing framework, the court cannot treat their services as legally compensable.
And upon receiving it, it was received in my office. I didn't quite know what to make of it, so I called counsel back to deal with what the court was supposed to do with that issue. The sum and substance of that is talking about, and I guess I'll begin there. It's just kind of the reverse of the order of proofs. But the sum and substance of that is that there is some accreditation, some licensure, something that makes what Ms. Tuco does, I don't want to use the word legitimate, but some type of therapy that the court should consider in this case. There are a few problems that I have with entering into that, not necessarily into that analysis, but coming to that conclusion. I, along with my staff, searched all over to find something regarding Ms. Tuco, the credentials to tie the therapy testified to into therapy that could be related to the offense in this case. And I'm trying to say this in the most respectful fashion I can, but I don't believe that let me back up a second. We could find no licensure in the state of Michigan, nor could we find any licensure, Ms. Tuco, in the state of North Carolina, where she now resides. And we found, in part because of what was sent to us regarding that therapy and also the testimony of the victim in this case, we found their accreditation page and searched for basically 3 different individuals. First of all, the individual who sent the letter, that's the February 2022 letter, vouching for the credentials of Ms. Tuco, searched for that individual, and which is basically, and we found that individual as being a member of that association. Then search for Ms. Tuco as well as the parents, and neither come up either under a search of North America, or of the United States, I should say, and or on the search internationally. They don't come up, which leads this court, given the evidence that's before it, to question the credentials to engage or have some therapy which would be related to this case. And I'm worried, well, I'm not worried. I make the specific finding that I'm not sure that this is even a business. I can't Tuco's company or assume name, whatever it is, and ask for, during testimony, a proof of payment. Now, I will say that proof of payment, it was testified to, said it was paid through PayPal. Ultimately, I was provided, look like payments, but they're not through PayPal at all. They're through Cash App. And there are a series of them. And so I took those receipts or those payments and matched them to the invoices. What's clear to me in this, and I will make the specific finding, is that these invoices, I don't think existed prior to or at the time of the payment.
This is the moment the restitution claim effectively collapses. Once a judge finds that invoices may have been created after payments, credibility erodes, not because the victim is lying, but because the records no longer meet the court's reliability threshold. Courts rely on contemporaneous documentation. Receipts created after the fact look like reconstruction, and reconstruction, even if innocent, cannot support a court order. Judge Simpson walks through the dates like a forensic accountant. Payments preceding invoices, mismatched timelines, platforms that don't align with testimony. Each discrepancy widens the gap between narrative and proof. This isn't nitpicking, it's the foundation of legal enforcement. If courts accept reconstructed records, restitution becomes manipulable. What's heartbreaking is that this doesn't negate her trauma. It only means the system cannot legally convert that trauma into an enforceable financial obligation. The law isn't saying you weren't hurt. It's saying we cannot prove this expense in a way that allows us to compel another human being to pay it. And that is the brutal truth of legal justice. Pain without proof becomes invisible.
The reason I say that is because the payments and the invoices don't match up. They're not, some of them are not necessarily all that close if payment was made when services were rendered. and I'm going to start at the end, but then come back to the beginning. But I received a June 23rd payment to Ms. Tupko. And there's no invoice for June 23rd. And the court is not going to then consider it because I don't even have an invoice for that payment. But then when I go through, and now I'm going to go back to the beginning, there was a payment made by Ms. Morley of $90 on February 5th. That matches the February 5th invoice. And so that date matches. Go to the next invoice, which was February 18th. And one ought to pay very close attention to this because then the invoice says it was submitted on the 19th. Now, I guess theoretically that kind of thing could happen maybe, but the problem with that is that if the invoice is on the 19th, that means Ms. Morley would have made a payment prior to receiving the services. Typically not how that happens. And I would note just parenthetically that the invoices from Great Lakes Psychology all match when the payment was made. It says when the payments were made. Looks much like those receipts that one would receive at a doctor. But going back then to the 18th one, kind of matches, but she would have made it before then. Well, there's then a payment made by Ms. Morley on March 3rd. And again, that would have been a payment made prior to the invoice. And the invoice is March 5th. So again, I don't believe it happened that way. I don't believe that she paid before that happened, which leads me to some doubt as to these records that are being supplied to the court. And I don't mean that by counsel supplying them to the court, but the ones that were presented to counsel to give to the court. There is then a March 14th. The March 14th one, I believe, matches, if I'm not mistaken. The March 14th one. Where's that? There's March then 24th, and behind one page. The March 24th one also does not match because the payment would have occurred prior to the invoice date. Again, it's not something that would happen. Then the remainder of those for April 1st payment and for the I think it's June 9th payment, those match the exact date. So the conclusion that the court comes to in terms of looking at those invoices and looking through all of this closely, trying to find Ms. Tutko, trying to see if she has any type of certification for any therapy, listening to Ms. Morley testify about how she came into contact with her. I don't think this has anything to do with the events or is directly related in any way whatsoever to the events of September 22nd. I do not, and I will say that these documents submitted to the court regarding this, the, put it in quotes, therapy that Ms. Morley received is of dubious nature and quality in this court's mind. And the court is not going to award any restitution for those particular items with regard to Ms. Tuco.
This is the formal collapse of the craniosacral claim. The judge doesn't hedge, he doesn't soften it. He draws a bright legal line. The court will not award restitution for this therapy, not because the victim didn't suffer, not because the therapy didn't help, but because the system cannot verify legitimacy, causation, or reliability. What's happening here is not emotional judgment. It's institutional self-protection. Courts cannot compel payment for something they cannot authenticate. To do so would expose the system to abuse, fraud, and endless subjective claims. This is one of the hardest realities victims face in court. Justice does not mirror life. It does not track healing. It tracks documentation. The law does not reimburse what feels real. It reimburses what can be proven to exist within recognized frameworks. Judge Simpson is effectively saying, I cannot attach the authority of this court to this. That is not a moral condemnation. It is a jurisdictional limit.
Again, specifically, the court would find that it's not directly related to the incident, which we're here for from September of 2023. Getting then to the, and let me just, before I leave the Tuco, and let me just also say that the letter that was sent, the information contained within, I don't think Ms. Tuco can make the diagnosis that she's making in this. I just don't see how she could with any representation, assuming this to have actually come from her, because I don't have letterhead, I don't have anything from what presumably is a therapist association, or a therapy business involved in therapy. Going to the Great Lakes Psychology, I don't at all have the problems that I had with Ms. Tuco's business. But the letter that was sent, the May 1st letter that was sent, and the court's going to quote a specific portion of that letter, which is the second paragraph, and it says, during her September 24th session, Ms. Morley disclosed the assault that had taken place by her employer and further shared the nature of their relationship. The primary focus since the event that occurred has been placed on addressing the trauma that has surrounded the relationship, in addition to addressing symptoms related to PTSD. What that tells me is that the only therapy that was directly related to the events of September 22nd was the therapy that occurred on the 24th of September.
This is the judge rebuilding the case in legal terms. He strips everything down to a single provable moment, the first session after the assault. That is the only point where causation is clean. The crime happens. The victim discloses it. Therapy addresses it. Everything else becomes legally ambiguous. Sessions before the incident existed for other reasons. Sessions after may involve overlapping stressors, workplace issues, and prior trauma. The court cannot separate those threads with certainty. So the law does what it always does when reality becomes messy. It contracts, it narrows, it awards only what can be directly, indisputably tied to the offense. One date, one bill, one line of causation. This feels unjust in a human sense. Trauma doesn't stop after one session. Healing doesn't conclude because a judge closes a file. But the court cannot operate in emotional continuity. It operates in evidentiary snapshots.
Because specifically, Ms. Klinsky clearly indicates that the rest of the time was about the relationship and symptoms related to PTSD from other events and processes and talks about the concern, her work environment, and the impact that it was having on her mental health. Unrelated to those events in this court's mind. Also, so that the record's clear, and it's very clear the testimony in court has considered it, therapy began prior to the September 22nd date. So there was therapy with Great Legs on the 13th of September, and then again on the 24th, and then there were therapy afterwards. This letter doesn't indicate that they dealt with the events or the actions of the defendant as it relates to this charge anytime after the 24th, when the event was relayed to Great Lakes. And so therefore, with reference to that, the restitution request on that, the court is only going to award the restitution for therapy for that one date. That's the only date, again, that is directly related to the events that the defendant participated in. I have no other proof that any time after that anything happened. So in sum and total, and for those reasons, the court would and will order restitution in the amount of $147.38.
From thousands of dollars to $147.38. That is the distance between emotional reality and legal reality. This number isn't a valuation of pain. It's a reflection of what survived legal scrutiny. Everything else failed documentation, causation, or legitimacy standards. To the victim, this likely feels dismissive. To the court, it is precision. Restitution is not symbolic. It is transactional. It compensates provable harm, not suffering in general. This is where many people misunderstand courts. They expect validation. They expect proportionality. But courts do not measure anguish. They measure liability. $147.38 represents the only cost the judge can confidently say was caused by this defendant. Nothing more, nothing less. The emotional impact of this moment is enormous. The system acknowledges the crime. It acknowledges harm. And yet, the tangible outcome feels almost hollow. Is this justice? Or is it simply the limit of what justice can express in numbers?
Now, with reference to and there were really three issues. That's the one issue regarding the restitution, which is going to take most of our time. There is then the issue regarding the violation. And I was going to take it into account in sentencing, but I think the court needs to make it clear what the court's going to do with that. And I'm a bit dismayed. I can only just put it that way. Dismayed, maybe a little bit angry in a certain respect. Mr. Stevens properly admitted to the violation regarding that contact because he wrote something on an envelope. Regarding mail that he had received that he believed should have gone to Miss Morley. It was relayed that, and so there, technically, because he wrote that, there was indeed this violation. Miss Morley, as she relayed it to probation and otherwise, was indicating that Mr. Stevens was trying to sort of tell her what to do or was making some threat. So at the last hearing, the only portion of the envelope we had was the one half of the envelope. Counsel for defendant had indicated that there was a credit card which was in that envelope. I couldn't see the full envelope, so I didn't know, but I know that there was a credit card coming. It was likely going to either be a blank envelope or it was going to say very little about the fact that it was a credit card that was in it. When I saw the full envelope, it's very clear that there was a credit card that was finally admitted. It was also very clear that to this court that the defendant wasn't attempting by any means to try to direct Miss Morley or anyone or anything else along those lines or threaten her in any way. The only thing he was saying is, this is addressed to you. I'm giving it to you. I hope you do the right thing with this. If it had been a company credit card, which I believe that it was, if it was a company credit card, it's his company. He, quite frankly, could have opened it and said, I opened it because I knew it was a company credit card and she wasn't supposed to have it at that point. But that's not what he did. And to be honest with you, I think he attempted to try to do the right thing.
This is a remarkable judicial reversal. The defendant technically violated bond by contacting the victim, but Judge Simpson looks beyond form and into intent. He sees no threat, no manipulation, no intimidation. He sees an attempt to return a credit card responsibly. And here, the judge does something rare. He vacates the violation. He publicly corrects the narrative. He acknowledges that the defendant was mischaracterized. This is judicial integrity in motion. Courts are not supposed to punish optics. They punish conduct. And when the evidence reveals that the conduct was misinterpreted, the judge restores balance. Notice how sharply he reacts to the idea that the defendant was portrayed as threatening. That matters. Courts protect victims, but they also protect truth. This moment demonstrates that the courtroom is not a one-directional machine. It can course correct. It can admit misjudgment. It can defend fairness even when emotion pushes in the opposite direction. Justice is not about choosing sides. It is about aligning consequence with reality.
What I'm angry about is the representation made to this court, my probation department, and everyone else that he was attempting to make a threat or in some way intimidate Miss Morley. Absolutely not. That is not what happened. Everything the defendant represented to this court regarding that envelope, that violation, turned out to be absolutely true the moment I asked for that full envelope. The court could verify. So therefore, while the defendant has admitted to that violation, I'm vacating his admission to that violation. I am not sentencing on the violation because while there was a technical violation, I don't believe that that violation was meant to be anything. He was just trying to do the right thing. So I'm setting aside that admission. And I'm doing nothing further with this alleged violation. Ms. Yermolenko, you have said that you have reviewed the report. There are no material deletions, corrections, or additions to that report. Is there anything you or your client would like to say before the court does approve that?
I'm going to ask the court to follow the recommendation. Thank you.
Sir, is there anything you want to say before I impose sentence?
Thank you.
It's a sentence of the court. I'm going to place you on 18 months prosecutor deferred sentence. You're to pay $555 fines and court costs, $540 probation, oversight fees, $147 and I think 38 cents is what I said, restitution payable to Kashmir Morley, payable through the court. When can you pay that, sir?
This is the architecture of consequence. The judge doesn't moralize. He constructs probation, financial penalties, oversight, behavioral constraints. 18 months is not symbolic. It is long enough to reshape daily life. Every decision becomes conditional. Travel, substances, associations, behavior. The court doesn't just punish, it regulates. The financial aspect may seem modest compared to what was requested, but fines and fees compound. They are reminders embedded in routine. Each payment reinforces that the system is still present. What's important here is proportion. The court did not escalate. It calibrated. No jail, no excessive penalty, just controlled accountability. This is what modern criminal justice looks like when restraint is applied. Not dramatic retribution, structured supervision.
Pay that today. The restitution would be paid in cash at the counter, or okay, everything else could be paid in. That's to be paid today. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as directed by probation. You are to complete a domestic violence program as directed by probation. There is to be no contact with Kashmir Morley, directly or indirectly. There's to be no assault or threatening or intimidating behavior. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll set a review hearing on this matter that is to be held September 16, 2024 at 1 p.m. I will order 93 days in jail. Credit for served, balance suspended. Thank you.
This case leaves us with hard questions. Should the justice system evolve to recognize non-traditional paths of recovery? Or must it remain bound to what can be licensed, documented, and independently verified? Where does compassion end and legal responsibility begin? What's undeniable is this: the courtroom is not built to heal. It is built to decide. And every decision is constrained by evidence, not emotion. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.